In the damp, drafty halls of 16th century Autun, a high court judge sits in solemn, silent deliberation. A capital crime has been committed. The accusations are grave, and the atmosphere in the courtroom carries the heavy weight of an impending execution. The defendants, however, cannot speak for themselves.
Because the accused, facing the gallows for the wanton destruction of the province's barley crop, are not rival farmers. They are not starving peasants driven to desperation. The defendants brought before the highest legal authority of the land are, in fact, ordinary rats.
The legal system of this era attempted to cross-examine nature itself. It was a period defined by animal trials, granting formal legal proceedings to non-human entities. Beasts of the field were treated as subjects of human jurisdiction. But the defense that would ultimately save these rodents didn't rely on mercy. It relied on a cynical, brilliant exploitation of the judicial machinery. The strategy that unfolded in that courtroom is known as the cat stratagem, legal legerdemain in Autun. At the center of this legal defense stood Bartholomew Chassenée, a rising star in the French legal world, who approached his rodent clients with absolute gravity. He launched a meticulously constructed strategy to shield them from the gallows, relying on two distinct maneuvers: the Pulpit Summons technicality and the Mortal Danger Loophole. The prosecution expected a swift victory, demanding a summary judgment against the vermin, but Chassenée paralyzed the court. He successfully argued that because the rats were scattered across hundreds of distinct villages, a single legal summons was legally insufficient to notify the entire population. He forced the court to mandate that a second citation had to be read from every single pulpit in every parish where the rats resided. This geographical technicality ground the wheels of justice to a halt, delaying the trial for weeks. When the appointed day finally arrived and the rats inevitably failed to appear on their court date, the prosecution moved for a conviction by default. They demanded a swift, summary victory following the defendant's absence.
Chassenée stood before the judge to deliver a legendary masterstroke. He didn't argue that the rats were innocent of destroying the barley. He argued that they were terrified. He informed the court that his clients were entirely willing to appear in court and answer for their crimes, but they were being blocked by their mortal enemies. The streets of Autun, he pointed out, were lined with waiting cats. The strict legal standard of 1510 established that if a defendant could prove their journey to court was demonstrably too dangerous, they could lawfully refuse the summons. Invoking this exact standard, Chassenée argued that no reasonable court could expect the rats to commit suicide just to attend a hearing. To force their travel would be a direct violation of their rights under the law.
The judge was trapped in his own logic. Bound by the very statutes he was sworn to uphold, he agreed, and the case against the rats was dropped. Against the full might of the state, it was an impossible victory for the rodents.
The profound aftermath of this case cemented the lawyer's legacy, highlighting an enduring conflict: the law versus the chaos of nature.
This defense was far more than a courtroom performance. It cemented Chassenée's reputation as a genius forensic orator. He later wrote the definitive treatise on the criminal prosecution of animals, meticulously arguing that beasts deserve justice safeguards. He laid down the philosophical framework for granting due process to the natural world.
But the historical mystery deepens when we examine the aftermath of this philosophy. Years later, Chassenée would stand before the Parliament of Provence. His clients were no longer rodents, but persecuted humans. He utilized the exact same foundation built in Autun to mount a defense for the Waldensian heretics. The core of his argument before the Parliament rested on an inescapable logic. If we grant the right to a defense to rats, how can we deny it to humans? The right secured for vermin in a damp, provincial courtroom had inadvertently formed the vital legal foundation for defending human lives against religious persecution. These animal trials were not a glitch in the medieval system. They were a necessary feature of a society desperate to believe God's order was absolute. By applying the rigors of the court, humanity was attempting to control the chaos of pestilence through the law, believing even nature's destruction could be legislated into submission.
The terrifying absolute power of the era's legal system meant the gallows waited for anything with a pulse. If the sheer brilliance of legal legerdemain shielded the rats of Autun, what would that same unyielding law do to the Rooster of 1474, a bird condemned and burned at the stake for the unnatural crime of laying an egg? The law stood as the ultimate arbiter, the only barrier, and the greatest threat between the living and the executioner's flame.